Good evening, everybody. This is Jonathan Ginsberg, and welcome to the live stream, the Wednesday night live stream. Today, I have a guest, a special guest. I think you'll find what she has to say very interesting, very interesting. Interesting, it's easier for me to say. Adriana de la Torre. Adriana is an appellate attorney. She deals with federal court action, and we'll talk a little bit more about what that means. But basically, cases that are denied at the hearing level will be appealed to the appeals council. And then if they're denied there, which many times the appeals council is a rubber stamp, it'll go to federal district court. And that's where Adriana does her work. And she represents people applying or trying to get the federal district court to remand the case back. So we're going to talk a lot about some of the issues that she sees at the federal court level, which eventually make their way back to the hearing level, mistakes to avoid, both as a claimant and as an attorney, just a lot of different types of things. So Adriana, welcome. Thank you for your time. I really appreciate you being here with me.
Thanks for having me. I'm really excited.
Absolutely. Absolutely. Okay, so I know we normally ask a lot of talk questions. Before we get into that, I just want to ask a few questions just to let everybody know a little bit about federal court work and sort of how it differs from hearing work. So let's just start with that. I mean, maybe I know you've seen every aspect of Social Security disability, but tell our audience a little bit how district court work is different fundamentally from hearing work, if you could.
So district court work is the first time that the case goes outside of Social Security's hands, right? Because up until that time, it's been the Social Security's local office. They did the initial and reconsideration. You have an administrative law judge who works for Social Security, and then you have the appeals council, which is a body of judges within Social Security. So federal court is the first time that Social Security doesn't have the final say as to what happens with the case. And it's really important because judges make mistakes all the time.
Yep.
So these cases go to federal court where somebody is telling Social Security, no, you got it wrong. There are times where they say, no, you got it right, and those cases are affirmed. But the cases that are remanded go back to the court, and they go back to Social Security, and they have to do a new hearing.
And they give them instructions when they go back. The judges and the Social Security judges are given specific direction by I assume by the federal court judges.
It is. What happens is the court will look at the case and they'll say, okay, these are the problems that I saw. Social Security, go do this again. But then the appeals council gets the case, and the appeals council can make its own decisions as to what the judge has to do. And then the judge is directed by the appeals council on having the new hearing.
Do you find that the federal judges are knowledgeable about Social Security? It seems like I know that, I kind of call it an alternative universe that we deal with. Do they know? Do they understand it? Do they have to educate themselves? Or is that what you do?
It's partly what we do, but there's a large percentage of cases at the federal level that's just Social Security work, right? They do a lot of different cases, but there's a large number of these cases. So it's not like they're only seeing one or two a year. They're seeing multiple every month, So it's keeping them quite busy. And because this area doesn't change the law all that much, they don't really need to re-educate that much at the federal court level.
Do you, and maybe a silly question, do you actually do live arguments? Is it done by brief? How would, when you present a case, what's the methodology of it?
It's different than Social Security at the agency level, because at the agency level, you're having that physical hearing with the judge and you're talking and the claimant is telling their side of the story. The federal court work is all based on what was in the record, what was in the papers, that's it. So you're not adding new evidence because you can't fault the judge for not considering something they didn't have. So what you're saying in federal court is, this is what the judge had, this is what the judge said, and here's why it's wrong. Now, most of this is done on briefs, on paper that the attorney submits. Sometimes the judges want to delve into an issue specifically, and they'll say, I want to talk to the attorneys. And so we'll have oral argument. where you go to the court and you talk to the judge for, 10, 15 minutes, and you say, this is why the judge got it wrong. This is why Social Security got it wrong. And here's why they need to do it again, right? Because it's not just showing that they got it wrong. They have to show that it was harmful, that there was an error that needs to be rectified. If not, it's just a paper error and nothing would have changed. There wouldn't have been any difference. So that's a big difference with the agency level and federal court work.
And when you do these oral arguments, are you doing them in person? Is it done virtually now? How is that being done?
So before COVID, I would go down to the courthouse
Right.
and I would appear and I would stand in front of a podium. Because of COVID, they started doing a lot of those oral arguments over the phone. No, the problem was that didn't really lend itself to oral argument mode, right? Because you're trying to listen to the judge on the phone and figure out when they want to ask you a question. So we haven't seen too many of those as of late. I feel like they're starting to come back. So that's a good question for like a year from now. We'll see if my answer has changed.
I mean, but you do cases in all circuits, right? You're not just limited to one circuit, or do you just do cases in one area?
We do a lot of cases nationwide. We do cases in Indiana, in Texas, in Florida, Wisconsin. We do a lot of different areas.
So would you have to literally fly to these different cities to make these oral arguments?
If the court wanted me to appear in person, yes. I have one oral argument happening in March, and it's going to be over the phone. So I won't have to travel to Texas for that one. But there will be more opportunities for travel.
Interesting. And just so people understand how you get paid, I know, and by the way, Adriana's got a very robust LinkedIn profile where she will take cases that have been decided. I guess some of them are your own, some of them are other people's cases, and kind of explain what this all means. And so if you're on LinkedIn, follow her, because you'll see some really interesting things on LinkedIn about Social Security cases. But I know there was some discussion on a recent one about the EJA fees, or Equal Access to Justice Act fees, where what the government pays your fee, is it you get paid win or lose? How do those fees work? Because people obviously are thinking, well, I've got this high-powered federal district court lawyer representing me. How do I pay her? And so tell us how that works. How do you get paid?
That's the whole reason why the equal access to justice came about, right? Because what happens is at the agency level, the attorney will get paid from the back pay. That 25% from when the claimant gets approved, that gets reserved to pay the attorney. But when you get to federal court, there is no back pay. The claimant's never been found disabled. So the way that works is that whenever you sue the government, be it Social Security, Treasury, be it any other department of the government, the court can pay the attorney from the general litigation fund. The court approves the award based on an hourly rate and the number of hours in the case. And then the Social Security Administration will pay, not from the claimant's back pay, not out of the claimant's pocket. They will pay the attorney for their time in the case. Now that's all subject to winning.
Right. So if you don't win, you don't get paid.
If you don't win, you don't get paid.
Oh, okay. So, which obviously leads me to the next question is, I assume that you're pretty selective about the cases that you take. You're looking for cases where there's been a clear error that you can get a remand. And so when you talk about winning, you mean the winning meaning getting a remand, not to say winning at the ALJ level. You don't have to win.
Correct. And that's a really important distinction, because when you win in federal court, what you get is the remand. The decision from the agency has been reversed and remanded. It goes back to Social Security. That doesn't mean that you get your check. That doesn't mean that you immediately start getting benefits. You just get a new opportunity to go back to Social Security and prove disability. You're in a much stronger position now. Why? Somebody already told Social Security you got it wrong, right? Judge, you didn't listen to this part. Judge, you didn't consider this. Judge, look at this treating opinions statement right here. It's going to tell you what to do. But you still have to go back to the agency and prove disability.
One question I get on the live stream sometimes is people say, well, if I get a remand, is the judge more likely to approve me? And my answer to that is some judges seem to react to getting slapped on the wrist, we'll call it that. Well, they're more likely to approve. Other judges kind of dig in their heels and say, I don't care what the, blankety blank district court said, I'm going to do what I want to do. And I don't know if you have any observations about that or any experience with that or even know about what happens after these cases when they get back. But I'm curious if you have any thoughts on that.
I think it really depends, right? Some judges may be like that, and some may just say, all right, I made a mistake. Let me do it again and let's be done with it. We have taken cases 4 times to federal court. It's
Wow.
gone back and forth 4 times. Now, when you get it sent back, it may go to the same judge, it may go to a different judge. It kind of depends on a lot of different factors. Say you have one judge who made that initial determination. It goes to federal court and it sends it back. That judge has since retired, moved offices, is no longer there. You're going to get a brand new judge. They're not going to have any issue with what the
Right.
other court said. They're just going to make a whole new decision because that's what it is. It is a de novo review. That
Yep.
means once it's done, it comes back and they have to do the whole thing over again.
Well, I know that again, I've had judges say to me at hearings, they've referenced the fact that they've been appealed, on a particular issue, and I want to do this right because I don't want to get appealed again. So I suspect that they are sensitive to, if a judge is repeatedly appealed and he keeps losing on appeal, he or she keeps losing on appeal, I suspect that doesn't look good for the judge. But again, I've seen some judges who just take it as a personal affront. Others, like you said, it's just part of the business. They don't take it personally.
There was one judge in particular that we used to know. He's since passed away, but he would read every district court decision on one of his cases. He would read it cover to cover, and then when you walk into that remand hearing, he would say, "I'd like to talk about your second argument," and then he would go into knowing that argument. But he was a very fair judge, trying to
Yeah.
figure out how can I be better. Right?
Right.
How could I have done this better? And they're trying to learn. So I do think that can help to educate them as this is what Social Security says, but there's a bigger world out there. And that's why the federal court is so important.
Yeah, no, it would be nice if, and again, I think many judges, and I think a lot of people here feel like it's just really unfair. And we're going to talk more about, what the future holds. But I think that, a decent percentage of judges do want to be better. There are a few, it's a power trip. And unfortunately, if you happen to get one of those, it's just a lottery. You're just out of luck, and there's not a whole lot you can do. Unfortunately, for some reason, Social Security tends to send it back to the same judge if that judge is still there, which never made any sense to me, but that's, I guess, what they do. All right, let me ask you about, there's a term that comes up in appeals, and you reference this in your LinkedIn articles a good bit. It's the term is substantial evidence. I'd like to kind of unpack that a little bit. And basically, way I read it, and tell me if I'm wrong, is that if the federal court feels like the judge relied on substantial evidence, or there's substantial evidence to support the judge's position, they're not going to disturb it. Tell me what substantial evidence means, and if I'm analyzing this correctly.
Substantial evidence is the standard of review. That is what the courts are looking at to see. There's different levels. Some of them are harder than others. Substantial evidence is just really such relevant evidence as a reasonable mind, right? A reasonable mind might accept. So if it's reasonable to accept that, then they would say, yeah, that's very low bar, right? It doesn't have to be more true than not. It doesn't have to be clearly true. It just has to be more than, reasonable. Like, okay, that sounds reasonable. The problem is that that's the only thing that a lot of the judges and OGC attorneys, that's what Social Security wants you to focus on, substantial evidence. But there is also legal error. Legal error is also when the agency fails to do something. They fail to follow a regulation. They fail to adhere to their own rules. That's legal error. That is different than really substantial evidence. When the courts usually want to affirm something, they say it was supported by substantial evidence. The ALJ's decision is supported. Why? Because it's such a low level. It's just what would be reasonable.
Okay, because I know, for example, as one of the cases you talked about was a court, I guess, made a decision that something was not past relevant work, but then denied the case on the grounds that the person could return to past work at step 4 of the sequential process. So, they're not following their own rules, because if it's not past relevant work, you can't deny it step 4, but they do it anyway.
Right. Those two findings are entirely inconsistent.
Right.
So
yeah, no, I remember I
that's
had a
why.
case years ago where a judge, found that the person, the person was over 50, so the grid rules came into play, and found that the person had no transferable skills and was limited to, let's say sedentary work, but denied the case because they had functional capacity to do, to do sedentary work. Like, wait a minute, that's what the grid rules said. So it is kind of
Right.
amazing to me that some of these mistakes were made. And again, my sense is that sometimes the writers, who write the decisions, may not be aware of some of these details, and they put these things in. The judges just kind of rubber stamp it, and it goes out, and it's definitely a mistake there. Um, and I assume most of the cases you get, other attorneys are referring to you, because most of us, I mean, for me, I'm in the trenches. I don't do appeals counsel, district court work, or very little of it. So I'm assuming that's where most of it comes from. Other people
Yeah.
that know who you are.
Mostly we get them from other attorneys. We also get a lot of veterans who think that because they have 100% VA disability, that they didn't need an attorney at the hearing. They were going to get approved. They somehow didn't, because 100% VA does not mean Social Security disability benefits.
Right.
And so then they find us and they say, hey, I didn't have an attorney. Can you take the case? We do. We will take cases for claimants who didn't have an attorney if we can still find the same arguments, right? Because the case needs to be supported. Not every case goes to federal court.
Yeah. Now, and again, and let's talk about that, because I know people do sometimes want to do it on their own. And one of the issues that I always tell folks is, if you're going to go to a hearing, realize that Social Security does not gather medical evidence after you request a hearing. So that if the initial and recon, the state agency adjudicators will gather evidence, but after you request a hearing, they do not. So theoretically, you could go to a hearing and the last evidence in there might be a year ago or a year and a half ago. What do you do in that situation? Is there any recourse when you get to the appeals levels in that situation? Or are they just out of luck?
Well, part of the problem is that the burden to prove disability, especially on the medical stage, to submit your records, to have the conditions, that's on the claimant.
Mm-hmm.
So if claimants show up and say, yeah, I mean, I have records, but I haven't gotten them, many judges, if they're unrepresented, will then say, okay, let's go and find out. We have to make every reasonable effort. That's what the agency says. We have to make every reasonable effort to develop the record. The agency does have that burden to develop a full and fair hearing. So if they're unrepresented and they have medical records that aren't in the records, many judges will go find those. They will go and put in the subpoenas and go get them. But what if you don't get that judge?
Mm-hmm. Yep.
Now you're going to be in a much more difficult position. And the other problem I find is that the claimants will say, well, no worries, I can get denied. I'll just refile. Unless there is
right,
not a good thing. Unless there's been a big change either in your age or condition, a substantial change, nothing's going to change. So Security is going to make that same decision.
Yeah.
So.
Yeah. Now, what would that be? I mean, if the agency has an obligation to develop the record, would failure to do so at the hearing level, would that be something that you could hang your hat on in a federal district court? Or is that
it depends.
Okay.
If the claimant has an attorney, that argument is very, very difficult to make.
Very hard.
If the claimant is pro se, that means that they didn't have an attorney at the hearing, then you're in a much stronger position, especially if there's some sort of component of their disability that would prevent them from getting the records, right? Educational difficulties, medical difficulties, mental conditions that might prevent them from understanding, I got to go get these records. That could be something, and the ALJ has the burden, has the duty to do that and represent the claimant by saying, okay, let me go get your records. They can reject the records by saying, there's nothing in here that's going to make me find you disabled, but they will oftentimes go and find the records.
Yeah. And I've had ALJs, literally, I've been in hearings where the ALJ will literally get on the phone and call. For example, there's a provider that will not release records. I'll have the judge call. I remember one judge, in the Atlanta area, he would call the provider and say, "Look, I need these records. I can have you come down here and bring them, or you can provide them." And
Right.
usually that gets them moving a little bit. But all right, let's talk. Because the questions obviously that folks have, and let me just get to a couple of those that I think that are really really relevant to our audience here. You listen to. I assume you see a lot of obviously records. You may listen to some hearing testimony. What are the mistakes that claimants make that make a potentially a winning case not a winning case? What are some errors that you see that people need to think about as they prepare for their hearing?
One of the big questions that the ALJs have is, what is a typical day like for you? What are your daily activities? What do you do? Do you drive? Do you cook? Do you clean? I find that a lot of claimants on cases that we can't do anything with is because they didn't build that evidence. At the hearing, they need to give details. When the judge says, do you cook, do you clean? You can't just say yes or no. You have to say yes, but, and you have to say no because, right? Do you do dishes? Well, no, because I can't stand there and my hands go numb in the water and I drop the plate. So then I now have an issue and I can't do that. And my legs were hurting and that was only after 10 minutes. That's very different from just no. And then the judge is saying, yeah, but why? Why can't you do the dishes? Now, most judges may not ask that follow-up question of why can't you do the dishes? And I find that a lot of claimants aren't proactive enough of giving that information. So that's one of the biggest things that we see.
Yeah, I think, and something we chatted about this a little bit before we went on, and I talk about this a lot during the live stream, is it's really important to give a narrative. At a hearing, is you're telling a story. You're basically positioning yourself as a reluctant claimant, somebody who doesn't want to be here. You'd much rather be working. You're recognizing that there's a social aspect to work. There is a, self-worth aspect to work. And you'd much rather be working, but you can't. And here's why, and here's what happens even around the house where you're just trying to cook for your family or clean. You can't do it. And as you said, what's the why? And to really make that connection between that herniated disc and the limitations you have, because your hands go numb after 5 minutes or something like that, and that you want to be very specific. One of the things I tell my clients at hearings, and I again talk about this weekly, is specific. Don't be, I can't sit very long, I can't stand walk very far, I can't lift very much. It's 5 pounds maybe twice a day, or I can walk 15 minutes and I've got to take a 10-minute break on my recliner. I can do that 2 or 3 times, then I'm in bed. It's really important to be very, very specific. And again, when you have to look at every hearing like, I want to make a record, but the judges are looking at it from the standpoint of, could you do any kind of work, right? So they want to see that. There was one case that you talked about, I believe, where a judge was sort of conflating activities of daily living with functional capacity. Let's talk about that a little bit, and just how that can be kind of dangerous. And maybe you can explain it better than me, but as I understand it, the judge was basically saying, well, you can do some cleaning and cooking, therefore that means you could work at a job. So is that kind of what was going on in that case?
It's exactly what happens. So what happens is that when you're at the hearing, and the decisions, they always focus on the medical records. And then there's always going to be a section that talks about, what did the claimant say, right? Because the medical records are important. They lay the foundation, but that doesn't necessarily get you the limitations, right? How do you take an MRI that someone has of their back that says stenosis to mean, okay, well, they can't stand for 2 hours. You have to have that kind of limitation from your doctors or from your claimant's testimony, from your statements about what you can't do. Problem is, some of the decisions read very much like the claimant testified that they drive a car, go shopping, use a checkbook, which, I mean, who even has checkbooks as often nowadays, right? And they'll identify a bunch of things, does the dishes, they'll get the mail, they'll use a Keurig machine. These are things that we've all seen in decisions. And then the judge will say, well, because these are a wide range of activities, I think they can do this work. has nothing, getting the mail, walking to your mailbox does not mean you can work 8 hours a day, right?
Right.
Going to go to Walmart to get your prescriptions, which is 10 minutes down the road, is not the same as sitting for 8 hours a day at a job. But yet, because they have to consider the statements, then they look at that and say, well, you can do more than you say you can. You're not bedridden, therefore you're not disabled. But that's not the standard. So that's why those explanations become real handy. Because if the judge says, well, they say they cooked, therefore they can do this job, then I can come back and say, yeah, but look at what they said about cooking. They said it was only a sandwich. They said they left the stove on. They've blown up things in the microwave. They don't pay attention to things. Somebody else has to be there while they're cooking. They can't carry the plate, so they have to sit somewhere else and do the. All those things are relevant, and the agency has to consider that. They may not like it, but
Hmm.
they have to consider that. That's in the regulations, it's in the rulings. What you say is important. It counts as evidence.
And it's
It
not
has to
just
be
what you say,
supported.
but giving a description, going into detail
Correct.
about it.
Correct.
Well, just in speaking of that, now we're going to get some questions. Are there any particular activities of daily living that seem to be most problematic with judges? Like, I'll give you an example, one that I see. For years, if somebody said they vacuumed, for some reason, many judges felt like vacuuming was equivalent to, lifting pallets
Mm.
hundreds of pounds of pallets of merchandise. Are there any activities of daily living that people at hearings or even at the administrative level need to be concerned about discussing without the explanation as to the limitations they have? Anything come to mind?
Two come to mind. The first is driving,
Okay.
right? You're on the road, you're using your legs at that time for the pedals, you're using your arms, you're using your head, you're moving around, right? So if you're saying you have trouble rotating your neck, you have trouble doing these things, you're driving, the judge is going to use common sense and say, yeah, but you drive. Do you not turn your head to go look at the other cars? So you have to talk about, yeah, but I'm only driving down the street. I'm only going 10 minutes. It's only once a week. And even when I do that and I'm using my neck and I'm doing this, it hurts. So then the next day, I'm in a lot of pain, right? I think the second one would be gardening. I have found that
Okay.
post COVID, a
Yeah.
lot of people have little things in their backyard that make them happy. They get outside, they have like a little pot. This does not mean that they're a landscaper, right? Digging ditches with trenches.
Right.
They have a little pot. So when they say I like to garden, it's not you squatting down on the floor and digging holes in things. You have to explain, well, this is what I'm doing. But I find that gardening and driving
Really?
are the
Okay.
two biggest ones.
I never thought about gardening because people do talk about that. And again, driving, yeah, and like you said, you've got to explain the limitations. But gardening, never really thought about that. And again, for me, housework, like doing picking up a basket of laundry, which may be 15 pounds or something like that. That could be an issue, or vacuuming, because again, it's pushing and pulling and possibly
Yeah.
reaching down, underneath something. Of course, now people have Roombas, and the vacuuming is more automatic, but gardening, okay, that's interesting. Okay, let's get to some questions because I've got a lot of people who have questions, and let's try to get to some of these. And let's just jump in one that I'm getting a lot of. Glenn asks, or makes a statement that he feels that President Trump and Elon Musk are going to make it a lot harder to get on disability. And I actually did a series of videos about this this past week. Any sense from your perspective about what's coming down the pike as far as Social Security disability in general, given the focus on saving money, reducing the size of the workforce of the federal government, making it saving the trust funds and so forth? Any sense of what's going to happen?
I think it's always been hard to get Social Security, right? Like I don't think it's ever been easy. Remember in the 80s when they did all those cessation cases and people were on disability, and then all of a sudden they were like, "Whoosh, you're out. Everybody's out of disability." That created some of the best case law that we have on what the agency's duty is, on what they have to do, how they have to consider cases. But I don't think that it's actually going to be that much harder because I think the process has always been hard. I think what they're going to focus on first is fraud. There
Right.
are some things that they can fix about fraud in the agency that have nothing to do with the claimants and the claimant's burdens or things like that. It's within the agency's control. They keep the numbers. They should know when there's a duplicate number. Why is it the claimant's burden? Right?
Yep.
So I think that that's going to be the first thing that they do. If they reduce forces, if they have less staff, only time will tell.
Yeah. Well, my sense is that, one of the things that both Musk as well as Bizignano, I'm not sure to pronounce his name properly, the new commissioner, they're going to focus a lot on using artificial intelligence to replace human beings. And yeah, artificial intelligence can do a lot of things. The problem is that transition period where they're moving away from human beings doing it to having computers doing it. There's going to be an adjustment period where the AI engines get trained and where,
Yeah.
human beings have to jump in and say, no, this is not done correctly. If those people are gone, we're going to see some real horror stories. That's the thing that really probably concerns me most. I mean, I don't
I
think there's
am
any
worried
question.
about
Yeah.
who's training the AI that they're
Yeah.
going to use, right?
Yeah.
I mean,
Yeah.
how are they training? Like,
Yeah.
there's a lot of that that I would be concerned about. But at this time, it's really too soon
Too soon to tell.
to
Yeah, I
tell.
mean, my sense also they're going to use AI to try to identify more people they can remove using CDRs. Who are the people that are more likely to have medical improvement, or more likely, and maybe they can associate part-time work with it. The people that are getting paid under the table, that kind of thing. So I suspect we'll see. And look, the one consistent that we've seen over the last 10, 15 years is that when Social Security does get money, it's usually earmarked for doing CDRs. They want, try to get
Yeah,
more people off of the system, especially people in their 30s and 40s who are going to be pulling on the
right.
trust fund for the next 15, 20 years. And one of the things you told me, by the way, earlier on was that a lot of the people that you're dealing with are people in their 40s, the young people under 50, where I suspect a lot of the case law is being made because the people over 50, over 55 have a decent shot at winning administratively. And even the judges with the low approval rates are going to, if they're going to approve anybody, it's going to be somebody who's 56 as opposed
Yeah.
to 46, right? So,
Yeah, so you have a 35-year-old who has significant mental health issues, and this is why they can't work. Because they're so young, the ALJ is going to go above and beyond to say, well, that record wasn't important. Your doctor's statement, well, that's not important. This is not a big deal. That's not a big deal. And that's how you get the denials. But why aren't those things big deal? Why didn't you look at this statement? Just because they're 35 doesn't make that much of a difference. The
mhm.
records are what they are.
Yep. Well, I think it's especially true in mental health cases because,
Yeah,
if you've got significant anxiety, PTSD, significant depression, or schizophrenia, bipolar, then you can be 35, you can be 55. It's not going to make you any more functional being younger. So that's sort of my take. And actually, you brought up another point that I just wanted to ask you about the treating source rule. That they got rid of that. What has been your observation about our judges? And just to explain what I'm talking about, there used to be, and I don't remember when they changed it. It used to be that a treating source was given controlling weight. So if a treating doctor, somebody you had seen for a number of months or years, gave an opinion about your functional capacity, Social Security was required to give that controlling weight. I guess is the way it said, and that a one-time doctor, the state agency doctor, or the consultative doctor, that would be given less weight. But the treating source rule goes away. And what has been your observation about what that means at the appeal level? Has that been a real problem for people?
So, so they changed the rule around 2017. And so claims filed after in March 2017 are now using no longer weight, but persuasiveness, right? So things can be very persuasive, somewhat persuasive. I mean, you can add any kind of adjective
Hmm.
before persuasive. What they're looking for at the end of the day is there an opinion? Is it consistent with the doctor's records, with the record as a whole, with the claimant's statements? I think most of the analysis of the treating source statements, right? Your doctors, your neurologists, I think most of the analysis of it really didn't change. I think it's just how they designate what they're giving or how much they're considering it.
Yeah. I mean, my sense is that that's as well. I don't see too many judges denying cases when you've got a, CE that says the person can work, especially a physical CE, which in my opinion are mostly garbage.
Oh,
But
yeah.
you've got a treating doctor, at a legitimate facility, let's say, for example, Emory University or Johns Hopkins or something like that. They're not going to ignore treating records from the Mayo Clinic and take the guy who's in a shopping mall who did a CE for 45 minutes 2 years ago and give that more weight. That's just not been my. I mean, they theoretically could, but
Yeah.
that generally is not what happens. I don't think so. Okay, here is a question. Michael asks, if someone is initially filed for disability requesting a closed period, is what he's talking about, providing they meet the rules. So basically what he's asking here is one of my clients. He's asking, does it make sense to ask for a closed period when you file your initial application? And my answer would be it depends. If the medical evidence suggests, lawyers are known for saying it depends. And, we're not going to ever give you a firm answer for the most part. But, if the medical evidence shows improvement, my experience has been that if you never want to be greedy. And as a lawyer, in other words, if the evidence shows the person's condition has improved, don't try to argue that, it's ongoing. Or if, somebody alleged an onset date, 3 years before they stopped working, don't try to argue that the work they did at more than SGA level was not SGA. So you just want to be realistic. You don't want to be greedy about it. So, Michael, the answer to that question would be, it's going to really depend a lot on the medical evidence, but yeah, you can do that. And, really at any point in the process, if it looks like the evidence shows you had surgery, you're doing a lot better, you can modify your request to make it a closed period. And my experience has been certainly at hearings, if you're going for a closed period, judges tend to be a little more open to that because A, it's not obligating the trust fund for indefinite period of time, and B, because they say it enhances your credibility. You're basically saying I've gotten better. So that's kind of my take on it. All right, let's see. Gary says, okay, this is a question, Adriana, maybe you can address. CEs. A lot of people get very upset and concerned about CEs, and he basically says, how long do the results take? And I'll answer that part of it. Usually the report's going to be out within a week or so, and your attorney can get that from the Electronic Express, download it for you. What is your take on the value that federal court would give, or appeals counsel for that matter, on the physical CEs and the psychological CEs? Any observations about that?
The problem is that they are supposed to be experts. Those CEs doctors, the doctors that Social Security sends you to go see, they're supposed to be experts in that field, right? They're supposed to be experts about Social Security, and they do these tests all the time, so they should know. I think it's really good, like he said in there, to make notes about what happened at that visit. They don't know, right? You see this very long records. They're like 6 pages sometimes, and it has blocks of things like, oh, this was fine, this was normal. It says height and weight. It says all these things. It says it checks their eyes. This is not an eye doctor, right? Like they're checking their eyes, and that's not really relevant. So you have a bunch of normal findings in there, but this exam took all of 5 minutes and nothing really happened. So it's important to really document that when that is the case, right? This is what happened. They didn't check this. They didn't weigh me. They didn't do this. But you have to submit that. You can't just keep that in, right? You can't just be mad about the CE and say, well, that doctor didn't know what he was doing when you get to the hearing. And the judge says, but you went to a doctor and he said you were fine, right? You can't then say, yeah, but he didn't know what he was doing and he took 5 minutes. You got to do that at the time that it happens, because that provides a lot of context. And that's all that happens at federal court. You provide context with what happened at the hearing. How long did the hearing last? It was only like 20 minutes. Is that really enough time for the claimant to tell their story? This was all the things that kind of were missing. What happened at that treating source opinion? Where did it come from? How long had they been seeing the doctor? You have to add a lot of context. And going to the CE, there's not context. You have to add it.
Yeah. So actually, what really might make sense would be after the CE to actually put together a statement, and there's Social Security, there's a form you can use, and so I would say call your lawyer and say, look, this is what happened, and so what you're saying is get that statement submitted as soon as you possibly can, so that it's part of the record, and then when the judge reviews the file, he or she will see that this consultative evaluation, it's because most of it's boilerplate anyway, as far as the report itself. And I will tell you again, from my experience, that the physical CEs are not always useless, but they can, be questionable at times. Now, we had John Foster on, who is a CE doctor. I had him on the live stream a couple of months ago, and he goes through a very comprehensive type of thing, and I think he does it right. But a lot of them are these, I call them industrial clinic doctors that insurance companies use to deny, insurance claims. And, like you said, they see somebody for 5 minutes. Now, one point I would make is that many of the doctors will say in the report, they observed you walking in from the parking lot. They observed you in the waiting room, and your behavior there was not consistent with what you were doing at the actual exam. So be aware of that. That certainly could be an issue. Now, my experience has also been that psychological consultative evaluations tend to be a little more reasonable because these are real psychologists who are, typically in practice. They don't do this for insurance companies, and I typically find they're going to, those reports usually are going to be a little more reasonable. At least that's just my observation.
Well, I also find that those are more in detail, right? So those take longer because they really do have like a history, and that's part of their exam. That's what they do every day for their sessions. They have to have, tell me about why you're here. And the claimant gets to talk about that. Then they go through a very detailed exam that can often have a lot of good findings for the claimants.
Yep, absolutely. Well, I like to say that, psychologists, they could examine anybody. They're going to find something. If they examine me, you'd probably take a team of them. They would find quite a few things wrong, but they can find something wrong with just about anybody. I know a couple of psychologists, like I'm very careful about when I talk to them. I just don't examine me, But now, one of the things Gary points out here, which raises another question, is he's taking 4,800 milligrams of gabapentin. That seems like a lot, but whatever, he's taking a lot of it. Medication side effects. How do the district courts, appeals courts look at medication side effects? Is that a relevant factor?
It goes to consistency. It is, right? They want to look at the side effects from medication because everybody's going to have them. But if your doctors don't note any side effects, and then you say, well, it makes me dizzy, and it makes me tired, and it makes me weak, but you didn't say that from the medications to your doctors, there's a real inconsistency there. And that's what the judges will pick up on. I am not that much interested in seeing, is this from the side effect from the medication, or is this just your condition? Is this a combination of your conditions? So I care less about where it's coming from and the fact that you're just having it. So I wouldn't attribute many things to just the side effects from the medication, because maybe if you weren't taking this, you'd probably still have these issues. Maybe they're components of your disability, right? Because any kind of condition, like if you have back pain, right, that may have some nerve damage as well. That may have some other issues that you could put for medication, but nowadays there's so many side effects from medications anyway. How do you tell?
Right. How can you tell? Well, I mean, I think that, medication side effects, and again, what you're saying really is, and this has been kind of consistent with what you've been saying all along, it's got to be documented. So realize that when you go to a doctor, they're trying to help you. They want you to be better. And so when you report to them something is not working, that's kind of inconsistent with what they're trying to do. A lot of times medical reports, medical files will sort of have like a history, and then it just kind of keeps repeating itself over and over. Doctors don't have a lot of time these days. So I would almost tell you, if you have side effects, put it in writing, whether it's an email to the judge or a letter or something, so that it's part of your record. Because if you don't, even if you tell the doctor, it doesn't mean it's going to get in the record. And I think what you're saying, Adriana, is that you've got to have this documented so that, you can point to it. I told my doctor I was having, what they call it, a GABA brain, or I was having, because of the Lasix, I'm having to urinate
Yeah.
every 35 minutes, something like that. You got to make sure it's in the record. It's not good enough to wait to the hearing and talk about that. You
Nope.
really need to do it as far as building your paper trail, building your record there.
And I
Because,
think that's one thing that a lot of claimants don't know is what do their own medical records say?
yeah,
They never look at them because they never need. They're going there for something specific. When they start looking at the records and they start saying, well, wait a minute, I didn't say that. Well,
right.
wait, I also said this, and it's not in there. There's no way that the doctor can get every single thing that you said at the hearing into that report.
Yeah,
There's just no way. That would mean, very, very long sessions.
right.
So it's important that you have to add that context. You have to show, you have to know what's in there to show whether it's right or wrong.
Yeah, and I will tell you that doctors, you have to be careful. You have to be diplomatic about it because I had a case one time where a client felt like the doctor was just not writing down some of the things that were going on, and he kept asking the doctor, please change this, please. And the doctor eventually fired him and basically said, I don't want you as a patient anymore. So you got to really kind of walk a
There's a
fine line
line.
there. Yeah, you got to be real careful not to be overly aggressive or demanding, but respectfully say, look, doc, this is important that this is in there, and I want this in there, and or not that I want this in there, but I want you to be aware of these particular issues, and whether it's side effects or a procedure that didn't work the way it was supposed to work, things like that. I mean, think about it. You're a doctor and you do a back surgery or a neck surgery, and your patient is fine for 3 or 4 weeks, then starts having all kind of problems again.
Right.
That says your surgery didn't work. So you're the doctor thinking, I don't want to get sued for malpractice. I'm going to kind of minimize the some of the negative stuff that's coming out of this because I don't want this to be in writing that my procedure didn't work. But as a disability claimant, you need that properly addressed. So again, you got to be
Yeah.
diplomatic about it. But I think you make a good point, and that is that if you read the record, and by the way, nowadays with patient portals, it's much easier than
Yep.
it used to be. I mean, used to be getting medical records was a real hassle. In fact, we were both on the 11th Circuit NOSCR meeting yesterday, and one of the things that NOSCR is working on is they're trying to work with some of the big medical record. I think what is the I forget the name of the company that does a lot of the medical records, gathering for many of the medical facilities, and the goal would be to eliminate the need to actually get medical records the way we used to do it, the old-fashioned way. Because patient portals, some judges don't like the records that they're formatted from patient portals because they're sort of designed a different way. But
Yeah.
I think it's, what is it? I can't remember the name of it. I should know this. But
The
anyway,
patient portals are often like the discharge summaries, right?
yes,
You
yeah,
came in
yeah,
to see the doctor about this, and this was your blood pressure, this
right,
was this is what we're going to do. But what the agency is getting is your actual medical records. When the doctor is saying, okay, we weighed you, this is what when we tested your range of motion, this is what it was. When we checked your reflexes, this is what it was. Those are the records that Social Security wants. Sometimes
right,
those are not in the patient portals,
in
but
the
at
patient
least the
portals,
patient portals can direct you to where you need to go get the records.
right, right. No, absolutely. I think that getting records and having your own medical file is extremely useful.
Hmm.
Like you said, just because you need to know what's going on. Number two, you should have your own medical records anyway. Sometimes it's amazing to me. Sometimes judges will say, "What medication are you on?" I don't know. And people don't
Right.
even know what they're taking. I'm like, well, you should kind of do your own research. More people are
Yeah.
better about that now because it's online. All right, Mrs. Bell is telling us, I recently received a denial for benefits, although my former providers in Tennessee didn't submit records or offer to help, but got told they would request them again. In addition to that, they denied me medical without seeing all the records. The long-term disability insurance company says I work part-time. FCE says I can't work. Why doesn't SSA use, let's see, I do my reconsideration. Very frustrating, she says, because the previous burden. So I think what she's getting at is that, and this is again a problem that Social Security has because of their personnel shortage. You provide the name of the provider to Social Security. They're supposed to request the records, but if they can't get them, and maybe that's a question I'll ask you. The DDS medical or adjudicator is requesting medical records. The provider doesn't send them in. What do you do? as a claimant, what's your recourse? I mean, do you get them yourself? Does Social Security not want you to submit them? I always get the sense they would prefer to get them because they don't want people scrubbing the records and taking out, stuff that could be negative. But what do you do in a situation like this where, Social Security is not getting the records, and they're denying it because they don't have all the records? What do you do?
You see it a lot actually at the initial level, right? Because you identify your doctor for where you go see your doctor, right? This is the facility that I see my doctor at. That's not where they hold the medical records, right? The medical records have to be sent to a different area. That's where you request the records. So
Hmm.
sometimes a lot of this happens very easily that they don't get the records. When the agency gets the records, they'll tell you on that form, these are all the records we looked at, and here's why we think you're not disabled. That's what technically, I suppose, reconsideration is supposed to be for, to make
Right, right.
sure that any of those that didn't get received are now at that time. Because then you say, well, wait a minute, you didn't get this doctor, and I've been seeing this doctor for 5 years. I think it's safer to just go ahead and submit the records yourself, right?
Yeah, yeah.
Because
I think so
is
too.
it easier for Social Security to do it because it doesn't cost you anything? You put the burden on them, but at the end of the day, you're the one who wants the disability benefits. It's
Right.
hard because it involves a lot of steps. So the question at the doctor is, who do we need to talk to get my records?
Right, right. Well, I'll tell people if someone's called the doctor's office and asked if I'm requesting medical record, what's the address I should use? Because it
Correct.
may not be the doctor's office. There may be many doctors' offices now are part of large, entities. Hospitals own them, or venture capital funds own them. So, getting the records may not be writing your doctor on Main Street. It may be a completely different state to get those records.
Exactly.
So that's something that you as a claimant can try to find out so that, when you provide it to Social Security or your lawyer, the records can be requested from the right place.
I think it's
Because and
important.
I'm sorry, go ahead.
No, I think it's important for claimants to have as much control
Yep.
over the disability application as possible. Because what happens is you submit your application and then Social Security goes and gets the records, right? They get the records from your doctor. They send you to one of their doctors to do that exam that we talked about earlier.
Right.
And then they have one of their own doctors review all your records to say what they think. And if you have very little control over the situation because it's all in Social Security's hands, that's why sometimes going to federal court is important, right? It's that step outside of Social Security. And when you get that remand, it's that vindication that you were right all along, that they've been making the same mistake from the beginning. So it's important to have control over that. So that doesn't just mean the medical records, it also means the function reports, because the
Okay.
agency will also send function reports to you at that initial level. Have control over those documents. That's where you got to talk about, these are all my problems, these are all my limitations. This is why I can't cook, this is why I don't clean. And that helps make that foundation, make that consistent, and make that supported application.
And when you talk about functional reports, you're talking about like functional capacity evaluation forms, things like that.
So the agency has a form that they'll ask you, what's a typical day like for you?
Okay. Okay.
These are
All right.
called function, yeah, these are the function reports. And not only will the agency have you fill it out, they'll
Hmm.
also send it to some family members and some
Right.
friends
Right.
asking about, how long have you known this person? How do you see them? What kind of limitations do they use? The function reports in that respect are very helpful. And I want claimants to have control over what they're putting out there. Like you said, it's their story. This is your time to tell it.
Yeah. Now I will say I look at a lot of those when I'm doing my hearing prep. I will look at the claimant's statement because again, this is in their own words. Closer to the time when they applied. Um, it can be, sometimes people do it written by hand, which I understand.
Mhm.
It can be hard to read. So, these forms are all available online. If you can do it that way, in my opinion, that's probably a better way to do. You can also add pages to it. So you're not limited to 5 lines if you need to explain more. But again, you want to really focus on specific limitations as to things you can do. And again, stay away from not very much or not very far. I also tend to use, when I can get them, a functional capacity evaluation. People call them RFC forms. That's really not what they are because
Right.
that's RFC is a legal term, but functional capacity evaluation because it really translates the medical findings into very specific work limitations. So if your doctor will do that, in my opinion, that can be very, very helpful as well. Okay, let's see what else we got going on here. Okay, Andrea is telling me that Madeline in my office is awesome. Yes, she is. Madeline is a legal assistant in my office. Madeline is in Oklahoma, and she does really good work. And she's really very, very, very nice to, very sympathetic and a great listener. So she's really good. I'm very, very happy to have her. Okay. Okay. Question about he won his case, which is good. They held some of his back pay about child. And I don't know if you ever, I really don't deal with this very much, but I believe the rule is, and you may or may not know, that if you owe child support or some form of restitution, they'll hold off on your past due benefits. I'm assuming that's what's happened here. They've been holding it for a couple of months now. I don't know that there's any limit on how long they can hold it. I think that they've got to just because there's all kind of rules about how long they're supposed to take, to make a decision, and it gets blown out of the water. They don't consider that. I'm thinking they need to hear from the child support office or its restitution, the state, to determine whether that's been satisfied before they release the money. That would be my thought on that. But I don't think there's any, 60-day or 90-day deadline. I just think that is just whenever they get around to it.
Yeah.
And there's a lot of in Social Security when they get around to it because they're just,
It's a waiting game for a lot of things.
It is. All right. Now here, Sweet Candy says, my online account says I submitted my application in January of 24. We conducted a non-medical review in November of 23. That doesn't make any sense because you wouldn't have a non-medical review before you applied. So let's assume she means 25. Does that does that term mean anything? A non-medical? I'm assuming that means they're looking to see whether you have any substantial gainful activity as of your onset date to determine whether you would still be disabled. In other words, if you're working over SGA, by definition, you're not disabled. So generally, if they're doing a non-medical review, that's probably a pretty good sign that they're going to approve you, but they want to make sure there's no work. This is kind of the way I'm reading that.
Yeah, I guess I'm confused as a question because I wonder if it's talking about eligibility as, because they do have medical denials and they do have non-medical denials. So if she's saying it's a non-medical and the timing of it, as I said, it
doesn't make sense. I mean, again, if they conducted, it wouldn't make any sense they would conduct a review before somebody filed an application. So I'm thinking she means 2025, because. So in other words, it sounds like she applied in January of 24, and then the case was kind of sitting there. And then in November of 25, which is almost 2 years later, they did a non-medical review, which would mean to confirm you have insurance credits, confirm you don't have any work, and
confirm you're eligible.
Eligibility. Because actually, date last insured is a big issue. One of the things I tell folks is if you stop working and you can't because you've got a medical issue, if you think you're not going to be able to work, go ahead and file, but don't wait 10 years. And I suspect you see this sometimes, but, trying to prove a remote onset, an onset that happened 7 or 8 years ago, very, very difficult to do because medical practices, they combine, records get destroyed. Trying to get a doctor to give you an opinion about your capacity, what it was 7 years ago, very, very difficult to do. So you're much better off trying to get your application filed, pretty quickly after you stop working, as opposed to waiting on it.
Oh, agreed.
Yeah. Okay. Michael Robert Jennings says, are my self-employment earnings averaged over the year? They counted in the month earned. I believe they're counted in the month earned because they're looking at this month by month. Because if let's say, you earned $15,000 in January of 25 and $17,000 in February of 25, but zero after that, then you could have an onset date of March 1. But if they average it over the year, then you might have more, if you average it over the year, it would look like you were at SGA. So I'm thinking they're going to look at your earnings month by month.
Especially with self-employment, they don't just look at the bottom line number, right? They don't just look at what you brought in. They look at what were you doing? And it doesn't have to meet that SGA standard that everybody else. It's a little bit different because you could technically pay yourself less, but do more work. So self-employment earnings are very difficult, and you have to really make sure that you're providing that context every single time, almost with every single finding.
Yep, absolutely. Now here's something he says. Now, again, this is not correct. I mean, he says if you're hospitalized for 31 days, you don't lose your Social Security. That's just, I mean, if you're incarcerated, you might, but I don't think you, being in a hospital, you would lose your Social Security. Have you ever heard anything like that?
I have not heard that.
Yeah,
There are in most hospitals social workers that
right.
if you are there after a certain period of time, they help you file for disability.
Yeah, yeah, yeah.
So I'm not sure. I haven't heard of that.
Yeah, no, I don't think that's correct. I don't think that if you're in the hospital, that does not disqualify you from getting Social Security. In fact, if anything, it makes your disability case that much stronger if you're
Right.
hospitalized for a month for something. But yeah, I mean, if you're incarcerated, I think that they can stop payment, but not by being hospitalized. So that this again, and you know, just for whatever it's
Ne-
worth, this is one of these things people hear. They read stuff on the internet, they see it on Reddit, they see it on someplace, and it's just wrong. But yeah, there's no rule. I would go far as to say I'm almost 99.9% positive that being in the hospital would reduce your or eliminate your right to get Social Security. Um, okay. Jean is 64 years old, on Social Security 32 years. For psychological diagnoses, concerned that Elon Musk will terminate. Well, Elon Musk is not going to terminate you. He's not going to be actually digging into files and looking for people to terminate, but
Right.
and so forth. But her concern is not to be facetious, is that there's going to be a lot more of these reviews. My experience has been that when you're in your 60s, the odds of being reviewed are just pretty light. I mean, they're looking for people in their 30s, 20s, 30s, 40s. You're close to full retirement age. They'll convert you automatically when you hit full retirement age. Gene, I don't think there's really much risk at all that you're going to be subject to a continuing review, even though it is psychological, and that would be an area that they will be trying to do reviews on, but not for someone who is 64. I just think that's
Yeah.
really, really
I
not
agree.
likely. Yeah. All right. And this is just, for folks looking for an evaluation. In fact, I should probably put that down here. I usually do. I'll put that there. Okay. Let's go back to comments here. No Sky, one of my regulars, says good evening. Good evening to him. Trish Wade says hello. Rodney is one of our firm's clients that we got approved with a very difficult judge, by the way. He is always here. We like to see him. Okay. 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 So U.S. Tech for 30 years, DOJ classifies you ultrasound tech. Okay. I was thinking United States. Ultrasound tech is like, that mean we have to show skills that would transfer to sedentary. Generally speaking, if you're at a certain exertional level, when you look at transferable skills, they need to transfer to a lighter exertional level. So yes, and I would tell you my take on it is when you have non-exertional issues like severe pain, like medication side effects, like things like irritable bowel or other things like that, that can be used to kind of erode transferability of skills. That's the way I look at it. So if you have a limitation, if you have an RFC determined to be light, and then you're looking at the grid rules and there are transferable skills, we can get rid of those by looking at some of these non-exertional issues, which would make it hard to focus and concentrate, therefore would work against transferability of skills, is the way I look at that.
And transferable skills is a really detailed analysis, right? You can't say general office work is a transferable skill. That's not detailed enough, right? Answering the phone, those are things that are just general or things that you learn just doing regular things 30 days. Skilled transferable skills are things that you have to have learned by doing the job day in and day out for that period of time that it took to learn it. So there may not be a lot of, ultrasound techs that
Right.
transfer to sedentary, but it would be important to know not so much what the skills are, as what are you still able to do, right? Because if it's less than sedentary, no skills, there's no
Right.
skills that would matter.
In many jobs, there are no transferable skills to sedentary job because by definition, being an ultrasound tech, for example, you're going to be having to move around. I can't see that being a sedentary job anyway. And many of the times the vocational witnesses will testify that no skills transfer outside of this very narrow profession. And so that gets rid of
Right.
them as well. Yeah, I think, and look, I think being the ultrasound tech for 30 years, that goes to your credibility. You a hardworking person, did a helping profession. That is not the type of person that, a judge is going to think is going to be looking for early retirement. So I think all those things work in your favor. So I suspect that we won't have a lot of problem with transferable skills, using a grid rule analysis. Um, okay. Laura James says, first time here. Thank you. You're very welcome. You're very welcome, MKDD.
Oh, I'm just seeing now that there was a pretty bad echo.
Okay. Yeah. Well, I that might have been on my end, and I basically, I don't know if we're still hearing that. I turned my volume way down, and so that the echo might have been from my speakers going back into my microphone. So hopefully that did not happen, but we'll see. But yeah, we did have a little bit at one point. In fact, one of my staff people texted me early on saying there's an echo, so I turned my volume way down. So I'm making sure it's loud enough I can hear you, but I'm meaning to look at getting like an earphone or something like that. Okay. Blue Z says it's a drift. If kids under 18, you get approved, they get some benefits. Those are called auxiliary benefits. And yes, you would be on SSDI, not SSI, but SSDI. You would get auxiliary benefits, which there's something out there called your PIA, your primary insurance amount, and it will give you, there's a family max. Generally speaking, if you have a couple of kids, they'll get about an amount, not taking out of your amount, but in addition to what you get, about 25% of your benefit, I believe, is the number. But again, it's subject to your family max, and those are calculations that Social Security will do. Sometimes I can see them, sometimes I can't. But yes, if you have minor children, they would be eligible for auxiliaries.
And I would want to just make a quick designation
Yep.
about when you say Social Security, the question says Social Security. And
Yep.
as Jonathan said, there are two different types, really. There is disability insurance benefits and supplemental security income. If you're on disability insurance benefits, that's Title II, that's where your children can also get disability benefits. SSI is income based, so that doesn't necessarily translate down to the children. So it's an
Yep.
eligibility issue for the different, they're both the same definition of disability.
Same
The
definition of
difference
disability.
is where's the money coming from? Is it coming
Yeah.
from your earnings that you've done into the system, or is it coming from your low income?
Actually, that raises a question of somebody I talked to, a potential client I talked to today. She was approved for SSI, but denied for SSDI. Why would that be? Why would they do that? I mean, she's insured. Why would they approve her? I mean, I know SSI, there's a presumptive thing, but I mean, that just made no sense to me. Why she got denied at recon, but she was approved for SSI. Any idea why that would
What was her
happen? I mean,
date last insured?
that's what I'm thinking. I mean, I sat, and I have to look at the file, but I mean,
Yeah.
we went through her income, her earnings, and I'm doing the calculations in my head. They're all 4 quarters, up until the last year or two, she's got all 4 quarters. I mean, it doesn't look like there's a date less insured issue. I have no idea. Now, when I look at the file, that may explain it, but I don't have any idea why that would be the case, but who knows? Just one other thing about Social Security, which makes it so much fun. Ron says, good evening. Good evening, Ron. K. Thunderer, thank you, and thank you. Madeline, Madeline, you got a shout out. You have a fan. Somebody said you're awesome. So there you go. So you're a madam, I guess, here now.
Okay.
So,
Thank you.
right?
Hi.
Okay, that's fine. It says heavy echo. Hopefully that's gone away, because like I said, I did change my settings a little bit. So we will see. That was early on, but right when we started. Okay. Laura says, I've got 25 diagnoses. That's a lot, including fibro, Sjogren's, stenosis, Hashimoto's, acoustic neuroma, leaving me half deaf. It's taken 2 years, haven't been approved or denied. Thoughts. Okay. I'll give you my thoughts. Adriana, you can give us yours. I think that when you're applying for disability, you probably want to focus on 3, maybe 4 major conditions. If you throw out 25, I think that's going to probably not be as helpful to Social Security. Um, and I think you want to focus on those things that can be objectively identified. Anything that is subjective, like fibromyalgia, I think that's less desirable. What's your take?
The softer diagnosis, like fibromyalgia,
Hmm.
they are harder, right? And so a lot of those diagnoses, it's very hard to determine what it's actually coming from, right? The fatigue and the pain, is it fibro? Is it from the stenosis? Is it from the sojourns? Is it something else? So the identifying all these diagnoses is less important than saying these are the symptoms that I'm having from it. These are the medications that I take for them. But I do think it's a good idea to identify them, right?
Yeah.
But don't think that that's going to be the silver ticket. That's not going to get you as far
Yeah.
as you want to go.
Well, in other words, and I put it this way: you don't win by a diagnosis. You don't
Mhm.
win, and you could have four herniated discs. You could be type 1 diabetic. You could have, you know, congestive heart failure. But you don't win because of a diagnosis. You win because of the functional issues that arise from those diagnoses. My concern is when you have 25 of them. It's like you said, it's very hard to kind of separate out what's coming from what. I would look at the ones that are most significant and identify functional limitations that arise. You can certainly include all of them in there, but I really like to focus on three or four because, and again, my perspective, you get in front of a judge and you have 25 diagnoses, you run the risk that a judge looks at you and says you're a hypochondriac, that
Right.
you're really invested in the idea of being disabled with all these diagnoses. You may have them, and maybe there's legitimate grounds for it. You may have medical support for it all, but that's, my opinion, the risk you run.
The other thing is that think about it as a lot of people have fibromyalgia, and it's
Hmm.
think of it on a range. There are people with fibromyalgia who can work, and there are people who can't. Where do you fall on this range? The
Yep.
agency makes it a point to say that we are not diagnosis driven, right? So diagnosis is not going to get you there. It's where do you fall on this range? And that's what you're trying to show.
Speaking of what we'll call soft diagnosis, let me ask you about what you've seen at the appellate level about long COVID. Are you getting any sense of the way Social Security is going to be evaluating long COVID cases?
I
Or is it
don't
still
think
too
it's
early?
going to, I think it's still too early, but I don't think it's going to be any different than how they started with fibromyalgia and
Okay.
what they're doing with Ehlers-Danlos. I think that what they're looking at is what are your symptoms? As long as the doctors have given you this diagnosis, what we tend to do is we submit medical journals, right? Have a study that says this is what long COVID is, and these are the typical treatments for it, which is
Right.
there's really not all that much. There is a lot of evidence on the Mayo Clinic about these are the symptoms of long COVID. You've
Hmm.
been diagnosed with that. These symptoms line up with what you're saying. You're now building a real good credibility case because there's so much about that it's like, oh, we don't know. That's what happened with
Right.
fibromyalgia. They had to make a whole ruling about what it
Right.
is. How do you diagnose it? If it's in the records, you got to consider it. And I envision that long COVID is not that far from that.
Yeah, my sense is that, and again, I'm also looking at some of the emergency messages that came out back in 2020, that respiratory issues and heart issues seem to be the things that move the meter most, as
Mhm.
opposed to other stuff. Now, what I have found, I've had a couple of cases just recently where the person had COVID and it took an existing problem. One case, it was a gentleman who had blood clotting issues, and it made it worse. Respiratory issues that made it worse. So I think long COVID is one of these things where you may have existing problems. You have COVID, and sometimes people have it 3 and 4 times, and then some of these existing problems that you're able to work through become no longer leave you without the capacity to do any kind of work at all. So that's what I'm kind of focusing on a little bit.
Yeah, that's great.
Okay. Okay. This Crystal says, I was approved at the hearing level. The appeals council is reviewing the judge's decision. Is that normal? How do they go about pulling cases? What's your take on that? So looks like it's a sua sponte, review by the appeals council. Are there any rules about that? Is that something that's appealable? What is your take on that?
So the appeals council can do that, and they can do that pretty often if they want to. It really depends on the cases. If they're looking for anything that seems out of the ordinary, that can be something. They sometimes do spot checks, just saying, hey, we're going to look at some decisions for this month and see what's happening. So it's not uncommon. You'd have to wait until the appeals council makes a decision. The sad part is the appeals council takes a long time. They have gotten better, but the appeals council takes a long time because the decision, when the appeals council decides on its own to review the ALJ's decision, because they can do that either by you requesting it or on their own. When they do it on their own, it can take a little bit of time.
What is, I mean, what would, is this a random thing where they do just kind of randomly, or is it based on maybe a judge with too high approval rate, or is it based on the condition? What prompts them to make a review like that?
There are quality reviews. They review that denials, they review approvals. They're looking for any kind of errors in applications, any things that they're going to have to retrain judges on. They're going to have to make sure that, okay, well, this seems to be an area where judges are misapplying the rules, so let's retrain them. I have a feeling that's going to happen with a lot of 24-3P and the new rulings that they have coming out about VE testimony, but it's not that uncommon.
Okay. And, you know, what's interesting, I've never had a appeals council review an unfavorable, make it favorable, but I've had a few favorables reviewed. I've never actually had one reversed. So hopefully that record continues, but hopefully with Ms. Crystal, she doesn't have that. And so you mentioned ruling 20, what is it, 24, what's the ruling?
3P.
3P. Okay, this is about vocational. I don't want to get too much in the weeds about this because it is a little complicated, but tell our audience a little bit about what this means. And I will tell you from my perspective, it just means that the judge is asking the vocational witnesses about their methodology for making decisions about jobs. But tell me, if you can, what this means in your perspective.
So anytime the judge has a hearing, one of the questions that the judge is trying to answer is, are there jobs out there that the claimant can do? It has to be in the national economy. The way to know that is with somebody who knows about jobs. So there are vocational experts or vocational specialists that the agency consults with, and they ask them at the hearing. So if a person could only sit for 6 hours and lift, 20 pounds, are there jobs that this person can do? Yes, they'll identify cashier, they'll identify ticket taker, and they'll identify, hotel attendant, right? These are the 3 jobs. But how did the VE come up with those jobs? It's a nationwide thing. They have to show where they came up with those numbers based on what numbers there are in the national economy. What kind of jobs would require that person to be standing for 6 hours as opposed to 4? What jobs would be part-time? What jobs would be full-time? So the Department of Labor has a lot of these information. There's a lot of other sources that have this information. And for a very long time, VEs were not divulging this information, right? So the VEs would just say, well, there's these 3 jobs based on my experience. Now, that has kind of changed, and so they're trying to open up the avenue for VEs to testify as to about what they're getting their information from, and that allows attorneys to really question that and dive deeper and say, well, let's talk about those numbers. So that is what that vocational expert is doing at that hearing. And that person is not there to help you, represent you, advocate for you. They are supposed to be independent and just talk about jobs and what jobs are in the economy and what people can do and not do at a job.
Let me ask you, you made me think of another question, the DOT, the famous DOT, which everybody, if you don't know what this is, it's the Dictionary of Occupational Titles. I think it was last updated. You were probably in diapers when it was last updated, 1990 something. This is the most absurd thing. This is a resource they've been using for as long as I've been doing this. And this thing hasn't been updated. It's got jobs in there that haven't existed for, 30 or 40 years. There are jobs that, in 1995 were done one way, but in 2025 were done the other way. What is, how is the district court, how are they looking at the DOT? What are they saying about it? And is that a good avenue for attack?
So because the ALJs and the agency uses the Dictionary of Occupational Titles, the district court uses it as well. Now, the agencies look at it just as, well, what is the job title and what's the number and what is the exertional level, right? What can you do at that job? But sometimes if you look at the DOT description of what they say they're doing at the job, like what this person does, there's a lot of inconsistency there, right? And there's a lot of things that you can pick up, and we argue that a lot, that this description that they have here doesn't line up with their abilities, right? Because it talks about occasional, if an ALJ says, well, you can occasionally deal with people, you can occasionally see other people. Well, if you're maybe a cashier, you're not really occasional ever. You're always in front of the public. And the same thing happens with a cleaner, right? They say housekeeper or house attendant. Well, how many times have you guys been at hotels and you see the housekeeper there and they have to talk to you because they're there and they're cleaning the room and somebody comes by. So the DOT is still fair game, and I find it more helpful than not when finding errors with the judge's decision, right? Finding inconsistencies with that job and what the ALJ said the claimant can do.
Yeah, and I think the other thing to point out about the DOT is that, over the past really year and a half, Social Security has been basically releasing these messages saying that, that vocational witnesses no longer can consider certain jobs, that they are by definition obsolete. Like for years, we would have to get past the surveillance system monitor. That was the classic, the easiest job that exists in the economy. And then they've decided now that there really are no such jobs, or that those jobs are not performed the way they're described in the DOT. And so they eliminated that from from determination. And other jobs that are designated as unskilled, in fact, are semi-skilled. The example I always give would be a copy machine operator. Back when when I started practicing law, copy machines were analog. You put paper on the copy machine, hit a button, it would come out. Now it's a scanner. And so you've got to go through 4 or 5 steps to scan a document and store it someplace, which is not really an unskilled kind of job. So yes, I
do you
think the
remember
DOT
tube operator?
Yeah, tube operator, right?
What they had at like the bottom of the estate, the Empire State Building, right?
Yep,
Those pneumatic tubes that used to go up, and
pneumatic tube operator.
they
Yeah,
would
that's
still say that in 2024. They're still
yeah,
talking about that. So they
yeah.
had to have an emergency message that said, you can't use this job anymore.
Well, then you'd have the jobs, fish. There was like fish, wrangler things, and I'm in
Yeah.
Atlanta, where we're landlocked. There's not a whole lot of commercial fisheries in Atlanta, but they would say, well, theoretically there's a job out here. So I don't know, but it's just my overall thought about it is, the Social Security has come out and said all these jobs are obsolete in the last couple of years. Well, what about the last 20 years where these
Right.
jobs have been used to deny claims, but they finally got around to recognizing they're obsolete? So what
They're
about
not
those
going to
people that were
reopen
denied?
all
Yeah,
those old
20 years
cases.
ago. Okay, JTL. I'm very scared I'm going to lose my disability against next CDR because of politics. Getting ready to turn 50. Again, I would tell you that the CDRs, I think, will increase. They always tend to do. That's one of the areas they're looking at. As you get 50 and above, I think the odds of having a problem begin to go down, because realize they're looking for the low-hanging fruit. And it's a lot easier to argue that a person 27 or 28 or 35 or 42 is likely to improve than when you hit age 50. It's just now the grid rules come into play. So there's more arguments to say why you'd be disabled. So I think, yeah, there's still a risk, especially if there's earnings that are showing up that you're working part-time. But, until we see it, I've not heard, I'm not saying on the listserv people talking about it. I don't think it's there yet. I think every year that goes by, the further north you get of 50, I think that the better you're going to be.
I agree.
Okay. Okay. So we've had, again, some echo here, and like I said, I think I got rid of it, but we'll see. Okay. Maria says videos help me win my case. Great. That's good to hear. Excellent. Okay. Let's talk about overpayments a little bit. This is a big problem. People are getting overpaid, and the reason they might be getting overpaid is they go back to work, they use up their trial work period months, don't realize they've used them up. They're working over SGA and realize the numbers, the tables are different. So trial work period is X number of dollars. SGA is a different higher number. So they use up their trial work period. They're over SGA. They don't know this in real time, and they get overpaid. This is a real problem because there's really no way to get an attorney to take a case like that without paying up front. And most people don't have the money to pay an attorney up front. You may not see any of this. I mean, my thought is that if they're overpaid, it's really, there's a request you can make administratively to have your overpayment waived. Hard to get that done. I've tried a couple of overpayment cases without success. I don't know if you see any of this, if you have any thoughts about overpayment, what people can do, but it is definitely a problem.
There's very few overpayment cases at the federal court level. I have taken one recently, and it was voluntarily remanded by the agency. So the agency didn't defend it in federal court. They sent it back and said, yeah, we agree with this. It's wrong. We'll do it again. That doesn't mean that it's going to get done right the second time, because I think overpayment cases are quite difficult. You can ask for the waiver, as you had said. You can show undue hardship. You can show that it was not, your fault. You can show a lot of things. But at the end of the day, they do say that it is the claimant's burden, right? Even if you tell them, hey, this is how much I'm making. Hey, this is what I'm doing. This is how long I've been there. If they just sit on it and keep paying you, then it's still your being on the hook. It's your fault, even though the agency knew or could have gotten it earlier. So
yeah, I would tell you, if you let's say you're working and you tell them I'm going back to work and you're still getting payment, obviously you can go to them and say, I want to get this stopped. Put it into a savings account, at least so you can pay it back, because and maybe earn a little interest on it. Because again, it can be really hard to communicate with them. I'm not a big fan of sending them checks back without proof that they got it, or that they know it's coming. Because again, trying to prove that you sent it back and that they got it can be difficult. But you just got to be really, really careful, because it's very, very hard, in my opinion, my experience, to convince them that it's that you were faultless in this, that it's really not going to be fair to you. They just don't care. I mean, and I think right now, especially in this climate, you're overpaid. It's real political. They don't want the word coming out that some guy got overpaid $50,000 and then Social Security waived it. It's just not, that's one of the things where I think the politics could come into play. Okay, Mark, who's one of my clients, says, got a notice that says, as soon as you submit the foregoing, which is probably a form, activities of daily living or disability report, we're going to review your case to determine if we make a fully favorable decision without holding a hearing. Standard language or hopeful. I think it's kind of standard language. I don't think that this means that you're going to get approved. I mean, I hope you are. Obviously, you're my client. I hope you get approved early. But I think this is more standard language. My take on it. But it's better than saying that we're not going to approve you at all. So at least there's something there. But I think it's just a matter of getting the form back. That's to encourage people to fill the forms out and get them back. By the way, I think part of it too. All right, T Lux says hello, T Lux.
And remember that at any point they could issue a fully favorable decision without holding a hearing. Like at any point, if they had enough evidence, they could do that. They often don't, right?
Yep.
So I would say that is standard language.
Yep. Okay, St. Louis Grant, who's a regular here. Okay. Is it ever a good idea to hold back arguments based on evidence and record in any brief or comment to the LJ for leverage purposes? No, I think you want to put it all out there. I don't think you want to hold anything back.
The district courts do not like the game of gotcha, right? So they don't want to say, well, if you had an opportunity, you didn't take it, especially if you have an attorney. They don't want you to say, well, we're not here to catch the judge and trick him into doing something. You have to put it all out there and then say, and we did put it out there and you still didn't consider it right. And here's why that was a problem.
I'm putting myself on mute, just hoping that will help with some of this as well. So that's what's taking an extra second here. Okay, so St. Louis also says, what are your thoughts about ALJ's underrating or lowballing write-ups from work that clearly align with market limitations, mental health? So I think what he's getting at is, you've been written up at work for, being disrespectful to a supervisor, to fighting with a coworker, having bad interaction with the general public, things like that. and it's in your file, and the ALJ in their decision basically says, I'm not giving that any weight. I think this kind of gets back to what you were talking about before, Adriana, is that you have to have documentation. That might be something that could be, if it's in the file, that could be discussed in appeal,
Oh, yeah.
possibly.
Anything that's in the file is fair game. If it's in the transcript, it's good. So I would definitely highlight that, and I would identify rulings that consider that, right? Like if, he's getting written up for being absent, tardy, not on task, look at 96 AP, right? And start talking about regular and sustaining work, continuing work. If he's talking about having issues with supervisors, coworkers, or the public, right? He got written up because he was yelling at staff and he was kicked out of work that day. I would cite 8515, and I would talk about how even examples of a younger individual who has social problems, significant social problems, and it explains what kind of social problems they could be having their performance supervised, right? That could be a problem that could still mean disability. So I would focus on that and really use those facts to bolster as much as you can those arguments.
And again, big picture is get this in the record,
Mhm.
and don't and St. Louis, do not hold anything back. You don't want to. This is like Adriana said. This is not about sort of playing tactical games or strategic games. You want to get it all out there, and because if you do need to appeal, the appeals council and the district court are not going to be real happy if you start bringing in things that were not brought up at a hearing. They won't consider it most of the time, I suspect.
So, for example, one of the things that we can't argue at the district court level, really, unless it was brought up at the hearing, is did the claimant meet a listing, right? If the attorney says, no, judge, the claimant does not meet a listing, and he does not or she does not medically equal a listing, it's very difficult in district court to say, well, yes, they did. The attorney already said that they didn't. So if it's in the record, then we're good and we can talk about that. But it's important to keep everything in context and bring it up at that time.
Yeah, it's interesting because years ago, I don't see it too much anymore, but a judge would say to me at the beginning of a hearing, are you arguing that this person meets a listing? And, I generally, if the case clearly doesn't meet a listing, I'm going to say, I'm not going to argue that. What if, that's an interesting question though. What if, you know, there is a possibility there. What would you tell, as an attorney, what would you tell me to do is to, I guess, probably have a listing in mind and say, well, we'd like you to consider this particular listing. That way it's in the record so that if down the road you need to make that argument, you could.
Yeah, and it's one of those where whenever you're walking into any hearing, you have to have a theory. Why is this person disabled? And a lot of the listings are very hard to meet. So many times a claimant will not meet a listing, but the listing is considering one condition, right? The listing itself is saying this is your back, you meet based on your back condition. But everybody out there who's filing for disability has multiple conditions. They have multiple issues. So you have to look at everything in combination. And so that's one, the judges also do that too. Identify for me your severe impairments, right? And you pick some, and then the decisions will say, well, he didn't identify this one as a severe impairment, so I don't need to consider it as a severe impairment. So it's really making sure that you lay everything out there for the judge. You come in with your theory, you come in with your facts, and say this is why this claimant is disabled.
Yeah, you mentioned the severe impairment because that's, I go to that step 2 or 3 of the sequential process.
Yeah,
I guess it's step 2.
it's
But
step
yeah, it
two.
used to be everything was severe, but now I'm seeing judges eliminating certain medical conditions because there's no support for it, no evidence of it, and saying these are non-severe. Their mental health is not severe because there's no evidence of it. It's just a bare allegation, or their knee problem is non-severe because there's been no treatment. So if you're trying to argue something is disabling, there needs to be some medical evidence to support it. It's got to be more than just what you say.
Right.
Okay. Johnny says he's not been working Thursday. Well, I'll give you, Johnny, this time I'll give you a pass. I want you here every other Thursday. Okay. No more excuses. I don't care if you're working what. You gotta be just kidding, obviously here. Okay. Shutter of the box. I'm a recovering alcoholic. If you're saying things I can do, I was told I could be a bartender. Okay, that's pretty rich. Okay, which I used to be. How in the world can this be common sense? Okay, so that's an interesting question. You're taking a case like this to appeal, and the person is an recovering alcoholic, and the V has identified bartending as a job. Would that be something that would be appealable?
Well, I think as I read the question, it says, which I used to be a bartender in the 90s. So that's definitely going to be more than 5 years ago. So I'm going to go ahead and say that that can't be past relevant work. But if they're saying that you could just do that in the general economy, they don't look at whether or not you would be hired for the job, whether or not your issues would, you can't get to the job site. They won't look at those things. They look at what are you able to do? Now, could the judge have included in your RFC a statement that says should not be around alcohol? Probably. I don't, and that would have eliminated the job. But I don't think that common sense arguments usually work that well in federal court.
Well, I think certainly at a hearing, if I had a VE, if I had a client who's a recovering alcoholic, and by the way, congratulations on being a recovering alcoholic. I mean,
Yeah.
I know that's can be a very difficult thing. I've had a number of clients with substance abuse issues, and they got past it, and that's admirable because I understand it's very very difficult to do. I would certainly, if I was in a case like that, I would say to the judge, like, I would certainly offer another hypothetical and say, that you would eliminate bartending as a job because the person, as a recovering alcoholic, this is really not an appropriate type of job for that person. I just think that would be pretty ridiculous. And somebody said later on here was a slap in the face. Yeah, it is. I mean, to say that is a job that a person
Yeah.
could do is really pretty disrespectful to the claimant. But it's unfortunate. What you're saying is that essentially common sense does not really have a seat at the table when it comes to Social Security.
You'd have to really say, you'd have to make the link, right? So, for example, you'd have to have had in the record that being around alcohol stresses you out and that you get too anxious around that kind of stuff, which is why you avoid it, which is why you can't be around. If you have said that, then you have a much stronger argument for this is not a job I could do because it includes that stress as part of the job. That's why the ALJ's decision, that RFC, what the ALJ says, this is the most that you can do, would include has to avoid stressors, including, right? For the same reason it happens to people with migraines, they have to avoid certain stressors like light and noise. So for a recovering alcoholic, which again, amazing, those are one of the stressors. Stress has to be included in any RFC. That's one of the rulings that the agency has. So if you've made that connection, even though it's common sense, unless you've made that connection, you're not going to have a good appealable issue.
Yeah, and I've had cases where women, let's say, who were sexually abused, will say, I cannot stand to have a male supervisor, or I cannot have, it could be male or female for that matter, men with facial hair, or men with, over 6 feet tall, whatever it may be,
Mhm.
cause me a great deal of stress. And again, I think what you're saying is you got to really bring that out, so that can become part of the profile, because really a hypothetical is a profile. And the goal would be, from our perspective, is to put as many limitations in that profile as possible, so that the vocational witness will say, that there are no jobs. All right, so we have now, all motor, a number of different comments here. Second ALJ hearing, it's been close to 3 years. They should stop paying 120-year-olds. Okay, I get to that. All right, so let's talk about the time frame. Have you noticed in your years of practice that the time frame for cases going up and back from federal court, has that gotten significantly longer in your tenure as an attorney?
So I have noticed that the appeals council decisions are coming in a lot quicker, right? I have noticed that once the case is already remanded from federal court, it goes back. Right now, the hearings are happening a lot quicker. The backlog at this point really seems to be the initial and reconsideration levels. Some of that is Social Security and some of it's not, because some of it's a state agency that Social Security contracts with to help them decide these cases. These are the doctors. So it really depends right now. I think that's where a lot of the backlog is. And that's probably where the 3 years have kind of been a problem. But
Yes, I also find that the real problem is more at the initial and recon at this point. The sense I have is that, especially with some of these more recent return to work workplace orders, that they've lost a lot of people. I've heard from a number of adjudicators, commenting on some of the videos I've got, that they're just really, really understaffed. I know that, there's a couple of blogs out there, where people are talking, about Social Security being not a real pleasant place to work. Charles Hall's got a blog, and I think he talks about that a good bit. So I think they have a challenge, because I think it's a difficult place to work. It's very stressful. They don't have enough people. Congress won't allocate enough money. So I think that, those backlogs are going to be a real problem. And when those cases do make their way into the hearing level, we're going to have problems there, because there's not enough judges either. So it's going to
yeah,
be an interesting couple of years, I think. Okay, Laura says, if you receive alimony or maintenance, can disability be denied because of that? No, not SSDI. That would be a non-factor. That would be a non-factor.
this is where, when we talked about the difference between the two programs really makes
Yep.
a difference in it, right? Because SSI is that you don't have enough income, and
Yep.
disability insurance benefits doesn't really look at that. They look at just what your earnings are.
All right, and No Sky puts up here. I did a couple of 3 videos that we were released yesterday about my thoughts about what what's going to happen with Social Security, given the real focus on automation, on AI, and what Mr. Musk is doing, along with the president, to to make government smaller. What does it mean? And I really tried in these videos is not to really offer opinions, just to sort of say what I think is going to happen. I know a lot of people have very passionate opinions about it, and there's been a lot of discussion in the comments. My goal, if you look at the videos, is just to say this is what I think may happen. We don't know; nobody knows for certain. But I think that there will be more effort to make things more efficient, to reduce the size of the workforce, to use more computerization. So yeah, I think that there is going to be a lot going on here, and this is going to be something we'll discuss, on this live stream, week after week, and I'm sure do more videos. But take a look at those videos, and just see what you think. Leave me a comment, because I think you'll find that there's a lot of interesting discussion going on. All right, this is more of a substantive question. Does back pain stenosis specifically have to be canal stenosis? What about bilateral neural foraminal stenosis of the spine? I think, again, we're getting into a diagnosis, and diagnosis does not tell whether you win or not. So whatever the diagnosis may be, and certainly, foraminal stenosis is a diagnosis of a problem in your spine. But what does it mean in terms of your functioning? That's really what Social Security is going to look at. So you've got to be able to sort of take that diagnosis and explain what it means to you, because there are people that have stenosis that are able to work, don't have any functional problems. Other people have mild stenosis and they are non-functional. So I think this is really about, explaining to your doctor, as Adriana said, in as much as possible, that those notes reflect functional limitations. If they're not in the notes, to supplement the notes if you can, diplomatically, and then when you testify, to talk about what this means to you, because that's really the issue in a disability case, not the diagnosis. Okay. Eric says hello. She's been here before. Hello, how are you doing? Let's see what we got here. Eric had a hearing last month.
Mm-hmm.
The judge says we received a letter. I received the mail and an award letter. What does that mean? Well, if you got an award letter that said you were fully favorable, that's a good thing. You want to see favorable, fully favorable. You don't want to see unfavorable on there. So assuming it was favorable, And there's letters to you saying that there's money coming. That's a good thing. That's a very good thing. That's what you want. Now, I would tell you that when you look at the decision, look at it to make sure that it says, fully favorable, because sometimes you see partially favorable. And I've had cases, I've got 2 or 3 right now, where Social Security approved it either administratively at the hearing, but they changed the onset date, and meaning that the claimant lost 20, 30, $40,000 in past due benefits. In those cases, you've got to make a strategic decision. Do you want to appeal? The risk is you appeal, you can end up with zero. Judge could deny your case. I've never had it happen, but it could happen. But when you appeal, you're putting everything back into play. If it's $40,000 or $50,000, you got to think strongly about it. If it's $5,000, $3,000, probably not so much. That's my take. Okay. Mike says, can I collect severance from my employer while waiting on a decision? I took a 4-month FMLA using my vacation sick pay, unable to, I don't see the rest. Oh, here we go. Had to retire because I'm unable to return. My severance is not based on me anywhere. Yeah, my take on that would be that severance, if you're not working, any money you receive, like accrued vacation, severance, sick time, things like that, that is not substantial gainful activity because it's not money in exchange for work. So I don't think in an SSDI case, severance is going to be an issue.
I would just make sure to document how much of it is severance and what was from your earnings, because they will have reports, right? So Social Security will pull earnings records and earnings reports, and they'll see that payment there, and then they might assume that that was because you were working or doing something for work. So make sure that if you get something like that, put it in context and make sure that you submit something that says this is what that was for.
Yeah, and I will tell you, at hearings, if a judge sees earnings after onset in the earnings record, he or she will ask what that
Oh,
is.
yeah.
But yeah, you want to be prepared to answer it, that this was accrued sick time, or I tried to go back to work. I had a hearing today. Unfortunately, my client is deceased now, but the judge was asking his widow, well, I see earnings here in 2022, and there's $5,000 of earnings. Tell me about that. Well, he tried to go back to work. He was able to make it for about 2 months. He had to stop. He was off for 6 weeks. He went back again for 2 weeks. He was off for another 4 or 5 weeks. He went back for another 2 weeks. That explains what the earnings are about. So I think that's a very good point that Adriana is making, is you want to make sure you can explain what those earnings are. All right, Laura says it seems inhumane to allow somebody to go without income. Unfortunately, this is the system. I mean, these cases can take 2-3 years. And yeah, people say to me all the time, how do I eat? What am I supposed to pay my bills with if I can't work and I'm not getting on disability? There is no answer to that. I mean, the only thing I would tell people is, if you think you're going to apply for disability, start planning early. Either save money or make arrangements with friends and family where you have a place to stay, you're getting support. It is a really, really difficult, and as Adriana said, it's never been easy. But I think that with the long delays, they've never been as bad as they are now. When I started doing this, somebody would apply for benefits, they would get a decision 3, 4, 5 months. Now it's a year. Some places it can be, I know in Florida where you're at, it can be a year and a half. It's really, really bad. So, but that's not a factor. And again, what you've got to do is you've got to reach out to your congressperson, your senator, and say, I need some help. I mean, that's what they're getting paid for. So you got to do that. But there's no good answer to that.
And the senators and the congressmen, they're going to be the only ones that can really effectually change on this, right? And push Social Security, and it's going to have to come from them. The more that they hear from their constituents saying, this was my problem, this is what happened, the better it's hopefully going to get one day. It's just not there yet. And it's not there.
No, and I think that they do a congressional inquiry, and I've had DDS supervisors tell me that when they see a congressional inquiry, that does get their attention. They move that case usually to the front of the line. So I definitely would take advantage of that. I mean, look, we're paying these folks a lot of money. They get gold-plated health insurance. It's a great gig to be a representative or a senator. I'm not saying it's easy. I'm sure there's a lot of stresses to it, but they depend on you. They want your vote, so they need to show that they're there for you. And they all have if you look at every senator representative's website, they have constituent services. So take advantage of it. Okay. All right. So Evie is a person with overpayment issues, staying at home mom, made 32 years on SSI. What do they do? Live in pain. They're threatening they owe them money. This is again a real problem because SSI is means tested, meaning that you lose your SSI if you have income or if you have assets, and that can be gifts from people. It can be an inheritance. And there is, SSI is, in my opinion, a really flawed program because they keep people in poverty. I mean, the income and asset standards have not been updated. I don't think I could ever remember them being updated. So, you are really in a bind with
Yeah.
with SSI.
It's a very low standard, and the SSI payment is really just to get you above the poverty limit, which isn't that much. Like it's ridiculous. So that is something that hopefully one day they'll change, but I
Not
don't
anytime
see that
soon.
changing
I don't
right
think it's
now.
going to be not anytime soon. Okay. All right. My pain does not allow me to have sexual relationship. The pain pills also exacerbate pain level. They know this. I would say this. I don't think that, again, not to be indelicate, I don't think that sexual performance issues are going to be a work factor. So I don't know that, and again, that could be a mental health issue, but I don't think that alone as a side effect would be enough. Now, you're talking about the rebound pain effect is what you're talking about there with the pain pills. Um, Again, it's got to be documented. And what you're saying, I suspect, is that you're taking pain pills, and that if you try to get off them, the level of pain gets even greater. That's got to be documented for it to be meaningful in a Social Security context. Because otherwise, you don't assume. You say they know this. You can. That's a very dangerous assumption. Don't say they know anything, because unless it's documented, they don't know anything. You've got to tell them, and you've got to tell them repeatedly, and you've got to tell them what it means to you. And again, if having difficulty with a sexual performance means that it causes problems in your marriage or your relationships, that may be a mental health issue that may cause additional stress. So you've got to connect the dots, as it were, I think. What's going to happen with Medicaid? Well, right now, Medicaid is a function. It's a state program, a function of getting on SSI. If I had to guess, I would think that SSI might be more on the chopping block than SSDI. SSDI, you've paid into the system. SSI, is more of a means tested benefit. So we don't know yet, but nothing at this point. But it is something that I would be definitely concerned about. And this person says that these companies that are prescribing bad medicine aren't helping. Again, that's probably not a Social Security issue. I think what you're talking about, obviously, there's been stories in the news about pharmaceutical companies, creating medicines that maybe have addictive properties or really ultimately not benefit. I don't know that that's really something that's tangential to Social Security. That's not really a Social Security issue. It may be something that you and your doctor can discuss. I know I've had clients tell me I do not want to be on opioids because of the risk of addiction. And under Social Security rulings, not following recommended treatment cannot be held against you if you have a good reason for it. And fear of addiction, I believe, would be a legitimate reason for that. Fear of bad outcome in a surgery. So you see that very much where people choose not to undergo procedures or take medications because of their concerns about side effects. And they get denied. Would that be something that would be appealable?
Yeah, I think that those are appealable issues because the ALJ has to consider that in context, right? So if the person can't have the surgery for other reasons, then that's something that should be taken in consideration because the ALJ is basically saying, well, you haven't had the surgery. How bad could it really be? You didn't get the treatment that you needed. But nobody actually ever said that that would fix everything. And here's my reasons for not wanting to get the surgery. But don't assume anything. And the best thing to do is make sure that you get that in before, right? So if your doctor tells you, 2 years ago you should get surgery, and then you get to the hearing and the judge is like, well, why didn't you want to do the surgery? Now's when you're just saying, well, I didn't want to have surgery. Here's all my fears of surgery. That really needs to be documented contemporaneously at that time.
Yeah. So again, I mean, the theme overall we're getting is that, the more you document those type of things, not wanting to under risk of addiction, fear of negative results, that, that sort of thing needs to be documented in your record, and don't wait to the hearing. I will tell you, a lot of people do wait to the hearing and they say it, and judges will understand it. If you're talking about a 4-level fusion, let's say, and you say, well, the doctor said that, the chances of success are 30%, the chances of failure of 30%, the chance I stay the same or 30%, and or 33%. I just felt like, it didn't make any sense for me. I think most judges can understand that. But again, the more that's in the record, the better I think it would be.
You know what I often find in that context is physical therapy. The doctor, you should do physical therapy. And then what happens is that they have a couple no-shows, or they didn't do the treatment sessions. They didn't complete all sessions. I'm assuming that the reason they didn't complete them is because when you're doing physical therapy, it gets worse before it gets better, right? And some people can't tolerate that it gets worse part because of other conditions. So as you need to document that, it can't just be no-shows, can't just be cancellations. So we see that a lot in context in the physical therapy records.
Yeah, no, I see it as well. People they stop
Mhm.
showing up, and then the physical therapist closes out the file saying
Yep.
person didn't show up. It's much better to at least say why. That it was just too
Right.
painful for me. It was too difficult for me to get there, whatever the reason may be. But I think absolutely what it is. Okay, we got about 5 minutes left, so we'll kind of go through a couple of these fairly quickly. Brad says, I was just told my second back surgery was botched by your family doctor. How do I ask for a doctor and paperwork on that? Again, your family doctor might be able to provide paperwork because he or she does not have an interest in that. That can be delicate because two surgeries. Normally my experience, if you've had 2 or 3 surgeries, at that point you sort of hit diminishing returns on surgery. So most doctors will report in their record that I think the word botched is kind of not a good word to use, but that just maybe was not successful in alleviating your symptoms. And I think that needs to be something you would document in the record. And if you're documenting that you're still in a lot of pain, unless the doctor is going to say, hey, everything is perfectly fine. I think that you're probably going to be able to get that into the record. Okay. Lulu says, I became addicted to pain medication, only function, but if I don't have them, I get a big headache. For some reason, I stopped driving the bus. Well, I'm glad you stopped driving a bus. You don't want to be driving a bus on pain medications. Now we get to questions about substance abuse a little bit. And, there are situations where you can become addicted to pain medications that are prescription pain medications. And that's not necessarily your fault, but I think that you would probably want to find a program that would help you detox from that. That would enhance your credibility. And then, your doctor would have to try to find another way to relieve your pain that is not opioid pain medications. That would certainly be a factor in your disability, because if you can't, if pain medications are the logical treatment and you can't take them, you become addicted to them, but you've gone through treatment to get, to get clean. I think that would certainly be an argument I would use as to why your work capacity has been limited.
Yeah, and those diagnoses are different than just general substance abuse or something, like meth or whatever. These diagnoses are different, and the ALJs know that. The agencies understand that. So that's something that they consider in that context.
Here we have, what if you can't hold your bowels after you wear adult diapers? I generally find that if you are in that situation where you are incontinent, either bowel or bladder, that most judges realize that's a really hard hurdle to overcome in terms of working, and that just the likelihood of having an accident or need to clean up or unscheduled bathroom breaks. Generally speaking, I find those cases tend to be approved. Most judges realize that is a significant work problem, and understandably so. So. Okay, we're just going to have time for a couple more here, then we'll finish up. Medical records are through the VA, I suspect. How do you get an e-copy? Yeah, the VA has a portal that you can get those records from, and they're going to be voluminous, I will tell you, but you can get them from the
Yeah.
VA. That should not be an issue at all. All right, Vince is one of my clients. Hello, Vince. You're a little bit late, but I'm glad you made it here. Okay, let's see here. And Laura, this is an interesting point. There are right. You know, I think that's a healthy way to look at it. You know, that you miss working, but realize that there's a certain threshold at every job. You've got to have a certain level of capacity to attend, to be reliable, a certain level of stress that applies in any job. And you know, if your medical situation is such where you can't get over that hurdle, then you are disabled. And I think that, you know, but going into a disability case saying, I don't want to be here, I'd much rather be working, I think that is that is a real positive for you.
Yeah, I think
Okay.
I think so too.
All right, and we'll make this our last point here, last question. Melody says, if someone decides to use a trial work period, and it's 9 months, not 90 days, by the way, 9 month trial work period. Yes, that's the whole point of it, and it's basically 9 months in any 5 year period of time. So you know, if you work, let's say in February of 2025, in 2030, if my math is correct, March of 2030, that February 25 rolls off. So it's a rolling 5 year period of time. But yes, that's the whole point of it, is that if you go over the trial work period amount, you use up one of your 9 trial work period months. If you are under the trial work period amount, which is like $1,100, I think, in 2025, you don't use it up. So if you use up 9 of those, you get your benefits during that time. So you get full benefits, your SSDI, you continue to get that during the 9 month trial work period. But once you use them up, then if you go over trial work period months, not a problem. But if you're under, but if you have to stay under SGA, because if you go over SGA, that's when you get into overpayment. And the problem is, let's say that over 4 years, you've gone through 10 trial work period months, and you don't even realize it because you don't know what the trial work period month, the number is. There's no real time tracking of it. You just forgot. And now you go over SGA. Well, you're in overpayment land. And at that
Right.
point, you got a real problem because you don't know it. You may not find out for 3, 4, 5 years, really. And all of a sudden, you get a letter from Social Security saying, you owe us $30,000. Here's an envelope. We want it in 30 days. That's where you run into the trouble. So, I think one of the things that Social Security would be really helpful for them to do is to have some sort of an online portal where you can check the status of your trial work period months, so but right now you got to keep track of it yourself. And as Adriana said, there's really not a lot of argument for appeal in that situation. So, okay. Well, I think we've covered a lot of ground. I really, Adriana, I really appreciate your taking the time to answer questions, give us perspective. Any final thoughts that people ought to keep in mind, given that, these cases do sometimes end up in appeal? And also, how would somebody get a hold of you if they have a case that has been denied and they want to appeal it and they need a federal court attorney? How would they reach you? And again, any of the closing thoughts you might have?
Yeah, I mean, I think it's, wonderful when we have an opportunity to help, because I do think that this is an area where we can. It's important to take that case out of Social Security's hands. They can't be the only one making the decision. If they are, it's not going to be in your favor. They've already denied you once, it's going to likely happen again. So going to federal court is a real important option for a lot of people. And so we're always happy to look at cases. And even if we can't go to court, because as I said, the standard is pretty high, right? It's only if reasonable minds could differ, if that's what substantial evidence is. So if we can help, we're always happy to help. You can always find us at towerlawgroup.com. Our phone number is 866-205-4014. You can give us a call, and we're happy to talk to you about your case, talk about what we think the ALJ got wrong, and if we can help move your case forward to federal court, we'd be happy to do that.
Okay, excellent. Well, I really appreciate that. And again, your number has been over your right shoulder the whole time, so
Oh,
if somebody needs you, um,
I forgot that.
that's great. That's ideal. You know, I've got I don't you've got the fancy background. I don't. I just have my office, a blurred office. I've got to get one of those fancy virtual backgrounds. I've got a green screen, but I don't really ever use it because it's kind of a pain to schlep up behind me. But anyway, so all right, we'll close the live stream. Hang on for 1 second for me, but we'll close the live stream. And again, everybody, thank you very much. We'll see you next Wednesday. And hang in there. Try to stay warm if it's cold where you're at. And again, we'll talk to you next Wednesday.